HOA used my cruise ship without consent. The consequences were immediate. The marina had always been quiet on weekday mornings. The kind of place where water lapped gently against polished hulls and the loudest sound was usually a gull crying overhead. It sat just beyond the edge of the coastal community, technically outside the HOA's direct boundaries, but closely tied to it through proximity and shared prestige. Many residents like to boast about living near the water, but only one homeowner actually owned something that turned heads every time it docked. The cruise ship was impossible to miss. It wasn't massive enough to rival commercial liners, but it was far larger than any private yacht in the marina. 3 decks high, painted in clean white with navy trim, it carried a name etched into the stern in elegant lettering. The vessel was fully staffed when in operation, meticulously maintained, and insured under commercial maritime policies, despite being privately owned. It represented years of careful investment, not just money, but planning, compliance, and constant oversight. The homeowner who owned it was known for being precise, quiet, and largely uninvolved in HOA politics. That distance had been intentional. While others attended meetings and debated paint colors and landscaping rules, the homeowner focused on business and kept community involvement minimal. The cruise ship wasn't a toy or a status symbol. It was an asset. That distinction mattered. On a Friday afternoon, while the homeowner was out of state attending meetings, the marina manager received a call from a familiar number. It was the HOA president. Her tone was casual, almost cheerful, as she explained that the HOA was hosting a special community appreciation event and wanted to provide residents with a unique experience. She claimed arrangements had already been discussed and assured the manager everything was handled. The manager hesitated. He mentioned ownership. The HOA president brushed it aside. She said the ship was community adjacent and that residents had always assumed shared access. She insisted it was a short cruise, fully supervised, and promised there would be no issues. Her confidence filled the silence, and before the manager could push further, she ended the call. Within hours, flyers went out. They advertised an exclusive HOA sunset cruise, complete with refreshments, music, and views of the coastline. Residents were encouraged to bring guests. The event was framed as a benefit of living in the community, a symbol of collective success and privilege. The cruise ship's name was printed clearly at the top. By Saturday morning, the marina buzzed with activity. HOA volunteers set up welcome tables. A temporary banner was draped near the dock. Residents arrived dressed for leisure, laughing, taking photos, unaware they were stepping into something profoundly unauthorized. The crew noticed first. They had been instructed by the HOA president to prepare the ship for a short voyage. She presented herself as having authority, referenced the HOA repeatedly, and implied prior arrangements. The crew, accustomed to dealing with designated agents and representatives, followed protocol as far as safety checks but flagged the situation internally. No written authorization was produced. No owner signature. No contract. Still, under pressure and reassurances that everything would be resolved, the ship was boarded. The cruise departed at noon. Music played across the upper deck. Drinks were served. Phones came out as the shoreline drifted by. The HOA president moved among residents like a host, soaking in attention, smiling broadly, speaking about community resources and shared opportunities. 2 hours into the cruise, an incident occurred. One guest slipped near the stairwell and twisted an ankle badly enough to require medical attention. The crew followed emergency procedures, documented the injury, and recommended immediate docking. The HOA president resisted at first, worried about the schedule, but eventually relented when the guest could no longer stand. By the time the ship returned to the marina, the homeowner had landed back in town. The notification came through an automated system alerting to vessel movement outside approved scheduling. At first, it seemed like a glitch. Then another alert followed, this one from the insurance monitoring service, flagging unauthorized usage and an onboard injury. The homeowner made one call. The marina manager answered, voice tight. Within minutes, the full story emerged. The homeowner arrived at the marina as residents disembarked, the mood still light, the damage not yet apparent. The HOA president noticed the homeowner immediately and waved enthusiastically, as if expecting gratitude. She didn't get it. Instead, she was met with silence and a request to step aside. The homeowner spoke briefly with the crew, reviewed logs, and confirmed what was already clear. The ship had been used without consent. No charter agreement existed. No insurance rider had been activated. Liability had been incurred without authorization. The guest who had been injured was already speaking with paramedics. The HOA president attempted to explain. She claimed misunderstanding. She insisted it was for the good of the community. She said everyone had enjoyed it. The homeowner listened without interruption, then stated one sentence that shifted the entire atmosphere. This vessel was used illegally. Phones lowered. Smiles faded. The HOA president laughed nervously, assuming exaggeration. She suggested they sort it out later and reminded the homeowner of community spirit. That argument collapsed under the weight of maritime law. By that evening, formal notices had been sent. The HOA was informed in writing that it had engaged in unauthorized commercial use of a private vessel. The marina received a cease and desist regarding any future access. The insurance company opened an investigation, and the injured guest retained legal counsel. The consequences were no longer theoretical. The HOA board convened an emergency meeting Sunday morning. The president tried to control the narrative, but details spilled quickly. Board members were stunned to learn no permission had been granted. Several demanded copies of agreements that did not exist. Panic crept in. The HOA's insurer declined coverage, citing unauthorized activity. Legal counsel advised that the HOA could be exposed to significant liability, not only for the injury but for regulatory violations related to maritime operation. Residents began to ask questions. Why had no consent been obtained? Why had the ship been advertised as a community amenity? Why was the HOA president acting unilaterally? The homeowner did not attend the meeting. Instead, legal filings were prepared. A demand letter outlined damages, regulatory violations, and immediate requirements for restitution. It also named the HOA president personally, citing misrepresentation and reckless disregard for property rights. When she received the letter, her confidence shattered. She attempted damage control, sending emails framing the situation as a misunderstanding and urging calm. The board responded by voting to suspend her authority pending investigation. By Monday, the injured guest filed suit. By Tuesday, the Coast Guard requested documentation. By Wednesday, the HOA's legal expenses had already exceeded the cost of the entire event. The cruise ship remained docked, its decks empty, the name on its stern suddenly associated with controversy instead of prestige. Neighbors avoided eye contact at the marina. Conversations hushed when the homeowner passed. What had been framed as a harmless perk was now a case study in overreach. And the fallout was only beginning. The fallout accelerated faster than anyone on the HOA board had imagined. By the time Monday morning meetings began, the situation had already slipped beyond internal damage control. What initially looked like a public relations embarrassment had transformed into a legal, financial, and regulatory crisis that no amount of confident emails or emergency votes could contain. The injured guest's lawsuit named multiple parties. The HOA was listed first for organizing and promoting the unauthorized cruise. The HOA president was named individually for misrepresentation and reckless conduct. The marina management company was included for allowing the vessel to depart without written owner authorization. The claims cited medical costs, lost wages, emotional distress, and negligence under maritime injury standards, which were far stricter than most HOA board members had ever encountered. The numbers were staggering. The HOA's insurance carrier issued a formal denial of coverage within 48 hours. Their reasoning was clear and devastating. The policy explicitly excluded maritime activities and unauthorized commercial use of private property. The cruise had been advertised publicly, involved refreshments, and transported guests, placing it squarely outside any conceivable gray area. Legal counsel delivered the news during an emergency board session. Every board member understood the implication immediately. Any settlement or judgment would be paid directly by the HOA or pursued against individuals involved. Reserve funds were insufficient. Special assessments would likely be required. Homeowners who had never set foot on the ship now faced potential financial consequences for an event they had not approved. The room erupted. Voices rose. Accusations flew. Several board members demanded to know why they had not been informed beforehand. The HOA president attempted to defend herself, repeating that she believed permission was implied due to the ship's proximity and prior informal conversations she claimed had taken place years earlier. No one backed her up. The board voted unanimously to remove her from her position pending the outcome of ongoing investigations. Access to HOA accounts and communications was revoked immediately. A statement was prepared for residents acknowledging serious procedural failures and promising transparency. The homeowner received the update without comment. Instead, attention remained focused on the regulatory side. The Coast Guard inspection expanded quickly. Logs were reviewed. Crew statements were collected. The unauthorized nature of the voyage triggered additional scrutiny into safety protocols and passenger capacity regulations. Fines were issued. The marina was cited for procedural lapses. The HOA was cited for operating an unlicensed charter. The former HOA president received a personal notice requiring her to respond to allegations of misrepresentation under maritime authority statutes. She hired an attorney the same day. That attorney advised silence. It didn't help. Residents began to distance themselves publicly. Online community forums filled with questions, frustration, and disbelief. Screenshots of the original cruise flyer circulated alongside excerpts from the insurance denial letter. Trust eroded rapidly. At the next community meeting, attendance doubled. Homeowners demanded explanations. They asked about financial exposure, legal strategy, and leadership accountability. The board disclosed what it could, including the possibility of a substantial special assessment if the lawsuit proceeded to trial. The response was immediate and fierce. A petition circulated calling for the former HOA president's permanent removal and personal liability for any costs incurred. The petition gathered signatures faster than any previous community action in the HOA's history. The homeowner, again, did not participate publicly. Legal proceedings moved quickly. Mediation was scheduled within weeks. During negotiations, the injured guest's legal team presented medical documentation, witness statements, and video footage from the cruise itself. The footage, taken casually by attendees, showed crowded decks, drinks in hand, and a general lack of supervision near stairwells. It was damning. The HOA's legal counsel advised settlement. The numbers proposed were high, but trial risk was higher. Maritime injury cases favored plaintiffs, especially when unauthorized commercial activity was involved. The HOA board authorized negotiations, but funds remained an issue. That was when the homeowner's legal position became clear. A separate civil action was filed against the HOA and the former president for unauthorized use of property, loss of income, reputational damage, and regulatory exposure. The claim was precise, supported by contracts, insurance documentation, and compliance records. The message was unmistakable. The cruise ship was not a shared resource. It was a regulated, insured, privately controlled asset, and its misuse carried consequences. Facing multiple fronts, the HOA made a decision. They settled. The injured guest received compensation that covered medical expenses, lost income, and damages. The HOA agreed to pay a significant portion upfront, with the remainder structured through a temporary special assessment. The former HOA president was required to contribute personally as part of the settlement agreement, a condition she accepted to avoid further litigation. Her role in the community ended completely. The homeowner's case concluded shortly after. The HOA issued a formal apology, acknowledged wrongdoing, and agreed to reimburse costs associated with the unauthorized voyage, regulatory compliance issues, and legal fees. A binding agreement was signed prohibiting any future use or representation of the cruise ship without explicit written consent. The marina implemented new access controls. The HOA rewrote its bylaws. Leadership training became mandatory. When the dust settled, The cruise ship remained docked, pristine and silent, its decks once again reserved for authorized voyages only. The homeowner resumed operations under tighter protocols, confident that boundaries were now clearly defined. The neighborhood changed. Residents became more engaged. Board decisions were scrutinized. Authority was questioned constructively. What had once been a complacent community learned, abruptly, that power unchecked could create risk for everyone. The former HOA president sold her home within 6 months. She left quietly, without farewell or explanation. The story remained. It was shared in nearby communities as a warning. HOA workshops referenced it as an example of extreme overreach. Legal forums dissected the case for lessons on liability and governance. For the homeowner, the resolution was simple. Ownership meant responsibility, but it also meant control. Consent mattered. And when boundaries were crossed, immediate action protected not just assets but principles. The marina returned to its quiet rhythm. Water lapped against hulls. Gulls cried overhead. And one cruise ship stood as a reminder that authority ends where ownership begins.